we can see, I don't know, maybe you can see it in my eyes, at this early morning at CPDP on a Thursday is the hangover session. We've had a party for the last 5 years called GDPR. Things were said, things that should have been done were not done. But we had a hell of a party and now we're hungover. And when we lost our minds, we at this GDPR party, instead of doing the GDPR homework we were supposed to do, instead, we drafted and passed a whole lot of new law. So now we have this hangover party. Thanks. Where we now have to reflect on 5 years of abject, dismal failure to enforce the GDPR and think, how are we not going to do that again with the DMA? I remember quite a few years ago lobbying US lawmakers, and I said to them, people, those Europeans, pretending not to be European, those Europeans have come up with this incredible data protection law that will allow nascent competitors to bring innovation to market. And for any Chicago school people who were listening, which is most of them, it'll give the consumer, some people are consumers, the freedom, the liberty to choose which parts of which business they're going to reward their data with. And they're shedding tears in their eyes at these thoughts of liberty and freedom and choice and consumers, consumption and markets and all that stuff. And they thought, okay, maybe Europe's got something. But Europe wasn't listening to me. And so now we have little bits of a GDPR clone wrapped up in something else called the DMA. So to unpick, that's the verb I hate, but let's do it. Let's unpack and unpick this mess. We have Stasi from Article 19. We have Klaus Wiedemann from the Max Planck Institute for Innovation and Competition. And we have Aurélien Mähl from DuckDuckGo. Now, their job, which they have not necessarily chosen to accept, is to explain how we are going to enforce this new mess, having failed to enforce the last one. And what we're going to do is we're going to stick to a very conventional format where everyone gets to set out their stall in an initial presentation, and then we have a cabbage fight. And you participate in the cabbage fight, and at the end of it, we're all covered in cabbage. So can we start off with Isa, who is going to set out her stall, and we'll take it from there.
Thank you, Johnny. I do endorse everything you said, especially about
cabbage,
the hangover as well. But yeah, so it is indeed something that has happened to me as well. As I work for a free speech organization, so and we have a sort of a global reach. So I was discussing with friends and colleagues from Latin American countries, and I said, well, we do have this piece of legislation, the DMA, and it's about gatekeepers, and it's about how the markets are going to work, and finally.
I think it's fine. Sorry.
Is that okay?
I think they were raising.
Okay.
Anyway,
okay.
Sorry.
It mentions end users, which is not consumers. It's not people either, but it's something similar, closer. Maybe we can discuss this. So it could be a good thing. It could be a good thing for civil society to keep an eye on it and see, what actually a proper enforcement implementation of it could mean for rights. And what we're supposed to discuss today is specifically looking at data protection and privacy and the relationship between the GDPR and the DMA. I do believe that there is even more expectation about the DMA enforcement because the GDPR has not been really enforced. So that's a good setting to start from. What I would like to do today, and I'll try to unpack later on, is start to say there have been so many other people already, good experts, much more expert than I am, discussing the specific data protection related provisions in the DMA, one by one in great details. I don't think this is what I want to talk. What I want to talk about today is, let's assume, because I think there is consensus on this, that there are some provisions in the DMA that concern data protection. Let's assume that data protection and privacy are elements that need to be taken into account when we assess the behaviors of the gatekeepers. What's the added value? Because for that, we already had the GDPR. So what is that we need the DMA for? What is going to change in my life if we do implement the DMA in a very good way, in a proper way? If we do implement it, end of the story. Let's lower expectation. I would argue, and this is once again a link to what Johnny has said, that the majority of so we do know that the DMA has two main goals: contestability and fairness. I would like to bring to this table another major thing, which is choice, as you said, freedom of choice, the possibility for end users, but also for business users, to make choices. Why so? I'll be brief, and then, as I said, I'll unpack afterwards. I do believe that there is one major mistake. Yeah, I'll be brave and say at 8:45 in the morning that this is a mistake, which is we're looking at the two goals of the DMA, and we're looking at the different provisions of the DMA in a fragmented way. We're thinking the two goals are contestability and fairness, and then we have Article 5.1, Article 5.2, Article 5.3, and 6.1, 6.2, blah, 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 blah. And we'll look at each of them separately. I'm not seeing enough discussions by people that look at the big picture. We're trying to say, okay, to comply with this specific provision, you need that little tweak in your behavior. To comply with the other specific provision, you need another little tweak. But what about the big picture? What about we're actually trying to achieve here? I would, my main call, and as I said, I promise to unpack a little bit afterwards, is that contestability and fairness are one goal. And every time we look at the impact of one specific behavior or one specific obligation on contestability, we also need to look at the impact on fairness. And this is the only way to look at the big picture, and this is the only way to think and realize that the DMA is about business models. Nothing more and nothing less. As I said, this is something I'll try to elaborate, but I'll leave it there. I think it's quite convenient as a moment to stop.
Just so it's clear, you're saying we're getting into the detail too early, and there's a few big questions that are left unasked. Is that it? That there's existential questions.
This is one point. The other point is we are playing this game by which we're considering each and every provision as a standalone. Mm-hmm. And so we're dangerously.
Isa, when you say we, do you mean the Commission?
This is in general in the debate. I'm also okay. I have to be honest and fair. Also, a number of experts, they're tempted to go very, very deep on what a specific provision means and how it should be applied. And I do understand, and I realize that some of these provisions, to identify, to think and shape what compliance could mean, is a difficult exercise. It might need different expertise, and we might need to have a sort of a multidisciplinary approach. We need different stakeholders to sort of identify what compliance means. But on the other side, if we keep if we go in that narrow direction and go deep on one provision and we lose the big picture, this is a mistake.
I am completely guilty of that. Aurélien?
Yeah, thank you. And I'm gonna, at the same time, go in some details, in some specific provisions, Isa. And on the other hand, look at the big picture. Just to remind that DuckDuckGo is a privacy company, the third largest search engine across North America and Western Europe. And we also blog trackers. That's what we do across the web, on your emails, on your Android devices, through our app and browser extension. Isa, you just asked what is going to change in my life if the DMA is properly implemented. And I think that the answer to this is that competition abuses can lead to privacy abuses. And in search, that abuse is very practical, and it's really Google hoarding of default positions and pre-installation deal, fueling the dominance of its privacy invasive search engine. And that's the pre-installation deals and the default positions, but also the friction, the unnecessary friction that we see when it comes to switching your search or browser default. And I'm going to give two examples that are addressed by the DMA. And that's, on Android, if you want to switch your search engine, this is going to take you about 15 clicks. And there are some places where you are not going to be able to do it. And the reason is that search is not just in one place usually, right? You would search the web through different places. So there would be your browser, your search bar, sometimes one more your voice assistant or the widget. And there is basically no easy switch. There is no simple button to do this. And that's obviously on purpose. Another example is on Chrome, if you want to switch your search engine, install our extension. You go on DuckDuckGo.com. We invite you to install our extension. It is being said very clearly that this is going to change your search default. And if you do it and then you search the web, Google is going to show you some scary pop-up that is going to tell you, are you sure you want your search default change? Do you want to go back to Google? And this is costing us something like 15% of the people that are going to go and install our extension. And so the DMA very obviously addresses these two things through a choice screen mandate, and then also there are provisions for easy switching. But the thing is, we know from experience, from the GDPR enforcement experience, that some companies are not going to think that this is obvious. And some companies are going to, find exemptions, loopholes, you name it, in the regulation to try and maintain these dark patterns, to try and continue making it hard to switch. And this is really where, I'm coming onto the enforcement point where we need to have a regulator that's extremely attentive to the details. And we need to have a regulator that, most importantly, sets up the framework, the incentives for constructive dialogue to happen between the gatekeepers, as they are named in the DMA, and the third parties, companies and also civil society, where the gatekeepers, they are invited to present mock-ups, to explain how they're going to comply with the rules, and then the third parties are invited to contribute. And this is something that has been talked about a lot, but we are yet to see the specific framework, the specific steps that are going to be taken to make this happen. And so, as a company, we are absolutely ready to contribute. We have started to do so, towards the Commission and gatekeepers. And now we are, expecting the conversation to start.
That was very, very smooth. We went from Isa saying we have to think broadly to my company needs this particular thing done. And that's actually perfect, because in the conversation, one of the things we need to get to is when you have a competitor that is trying to get something done, is that possible? That's an important part of this discussion. Klaus, you have a presentation.
Yes.
Do you want to sit, stand, dance?
No, it's fine.
Okay.
If you can hear me fine, then I'll sit here, and I think it should be. Oh, here we are. Perfect. So, can you what?
Sorry.
Yeah, it's fancy, isn't it?
Yeah.
Thank you. So everyone can hear me fine, I suppose. Thank you very much for this lovely introduction. And the topic I'm going to talk about is called the data protection implications of the DMA, a normative framework for the regulation of gatekeepers. So what do I mean by this overly broad, unspecific title? the point I'm trying to make is, or these thoughts I have, is that firstly, in my opinion, it is actually, and I'm an optimistic person, it is to be welcomed that the DMA now takes a normative approach to the regulation of gatekeepers, and that it actually tries, and this is a bit in line with what Isa was saying, to provide end users and consumers with both autonomy and choice. With that in mind, secondly, it makes sense that Article 5.2 of the DMA, which I will focus on in my presentation, focuses on the granting of consent within the meaning of the GDPR, as consent is arguably, and that's at least, I would say, a pragmatic approach, at the moment the most important tool that we have to ensure such autonomy and choice. So a very, very small and overview of the dogmatic links we have in the DMA that ties the DMA to the GDPR. And this is not an exhaustive list, but I think the most important ones, at least for the moment. So Article 5.2, which I'm going to talk about, says that a combination or cross-use, etc., of personal data is not allowed for gatekeepers unless end users have been given a specific choice on whether or not they agree and have given consent under the GDPR. So what is very remarkable here from a dogmatic viewpoint is that contractual necessity and the legitimate interests clause in the GDPR, Article 6.1b and f, are no longer feasible legal bases for gatekeepers in those exact situations. So it is actually a lex specialis for gatekeepers. It's a sector regulation for gatekeepers, which makes quite a significant, or imposes quite a significant change on the GDPR. Then we have in Article 6, number 9, an enhanced data portability right, which goes way further than what the GDPR contains. And in Article 15, this is a bit the odd one out, because it's not about obligations, etc. Well, it is an obligation, but more with a transparency twist. So the Commission must be provided with an independently audited description of any techniques that gatekeepers use for, and I really like this term, deep consumer profiling. So the idea is to allow data protection enforcement, and at the same time, it should incentivize gatekeepers to compete based on their privacy. I'm not sure if this is going to work, but I quite like this idea. So Article 5.2, well, the DMA pursues a normative approach, using per se obligations in Article 5 and 6, and it says, or it makes clear, that economic efficiency and welfare considerations are irrelevant in its application. There is no efficiency defense, as you have in competition law, and this is good because we've seen where it led us. There is a good lesson from the past that the tech giants could not be tamed with the traditional competition law. So this normative business model-based approach is, in general, I would say, a positive. So the DMA pursues a normative approach, and in the same vein, it promotes user autonomy and choice, which is human-centered, at least the idea behind it, and it does so, which is logical, by focusing on consent. So what I'm arguing overall, and this is quite in line with the gist of the DMA, is that a coherent approach is necessary when you want to, when you look at those business models where an excessive personal data processing takes place. So personal data protection, fairness and contestability, which are the goals of the DMA, and the competition law goal of reaching undistorted competition should be pursued in a coherent manner, because only if you look at it like this, you will get the whole picture, and you can consider all the legitimate interest of all the parties concerned. I think I lost. So what I was saying, this normative argument I was making, I think you can make a dogmatic argument as well. Consent serves as a dogmatic link or a dogmatic bridge between the GDPR, the DMA, and competition law. Under the GDPR, it must be freely given and informed. Everyone knows that. Recital 42 and 43, which are sometimes overlooked in these discussions, actually say, and this is the wording of the GDPR, that a genuine or free choice must be given, that a clear power imbalance between data subject and data processor are problematic, and that you must give granular consent options where it is appropriate. So there is a way to open the GDPR to consider market power considerations. For the DMA, well, fairness and contestability are the main goals. Terminology specific choice is in the DMA many, many times And that's logical, because contestability can only be reached when people have a proper choice in what they want to buy, what services or goods they would like to purchase. Looking at competition law, which is related to the DMA, but something different dogmatically, the ECJ has established competition law jurisprudence which can be coined a requirement of independence. That started with the Suiker Uni case and has become settled case law now. So what the ECJ says is that there's a concept inherent in Article 101 and 102 that each economic operator has to determine independently the policy that he or she intends to adopt in the common market, which includes the choice of the persons and undertakings to which he makes offers or sells. So we have this dogmatic connection in here. So I'm not saying that everything is perfect, of course. There are many open questions and many things that maybe could be better. So open questions remain. The terminology, specific choice in Article 5.2, I wonder, is it actually redundant? Because that is in the consent regulation of the GDPR anyway. I would say no, because if you put it like this into the text, then the European Commission can enforce it. And if a gatekeeper doesn't provide specific choice, then you have a rather clear case, and you don't have to get into the nitty-gritty of whether or not consent was freely given, etc. Then another question, which I think is more pressing, the relationship with Article 7, number 4 of the GDPR, and with the directive on digital content and digital services. What if personal data are really seen as a means of payment from the side of the gatekeepers? What if that's the business model? Do we have this paywall discussion reloaded that we had with these websites? It was mostly newspapers that said, hey, you can either consent to excessive third-party tracking or you can pay a monetary fee. Would that be possible for a gatekeeper now? Can gatekeepers demand monetary payment from those users who do not want to consent? I would argue that no, looking at the DMA, but actually when you look at the very text and the recital 36, 37, it's not that clear. So that's a problem, I think. And finally, that's of course the elephant in the room. Providing choice through consent, well, that's a nice concept, but it's only nice to the extent that consent really works in practice. And that, well, there's been much written and said about this, but of course users consent anyway, as some people say. Consent fatigue, the privacy paradox, etc. So the big question is in the room, what other non-paternalistic options are there to strike the right balance between the interests of gatekeepers and society and the interests of end users? So I'm through here. Thank you very much. This is my last slide. Thank you.
Klaus, thank you. And well done for steaming through the slides. This is much appreciated. Let me take you back to the beginning. What do you mean by the word normative?
Well, it's normative, human-centered, actually. You say that you don't look only at efficiency and technicalities, but you say, well, we have normative values that we want to enforce. If that works is another issue, but the idea is we have you could call it human rights-based approach, but maybe that would be too specific. We say, well, in our opinion, this behavior should not take place, and this is why we look at it. And we don't say, well, what about the different economic schools on this and that, and what is more efficient for the market, etc. No, we say we make a normative decision and saying this should be prohibited because we just think it should be, because that's our value we have.
Okay, got it. So it's absolute. You mean absolute?
No, it's not absolute. Of course not. No, well, normativity that's a very broad concept. That's something people like. Well, we will have different approaches. I mean, the lawmaker made a specific decision here, so you can say there is a normative framework in here, but of course you could have a totally different viewpoint. It's not absolute at all.
Okay, well, we'll move on. Let's yeah.
It's not so market based. It's not.
So not efficiency.
Yeah.
Okay. There's a question about the lex specialis idea, or whether there are two layers. But let's skip over that. I think it's too into the weeds. Someone reminded me recently that in 2013, Peter Hustings, who was then EDPS, made a speech about the interplay between data protection and competition. It might have been you, actually. Is that? And since then, we've had every now and again hints that should be so. And we had a clearinghouse. Never heard of that again. Don't know what happened. And now we have, and this sounds much better than a clearinghouse, a high-level expert group. Ching. But there's a question about what that is and what it means. I know you've thoughts about it. Tell us about this high-level expert group. Is this going to solve this problem that's now 12 years old?
I think the problem is older than 12 years, but yeah, we'll see. What can I say? I do believe that it's a nice path to go, and is a strong message, is a recognition that indeed at the enforcement layer, there is need for cooperation and discussion in between DigiComp, traditionally a competition enforcer, and data protection enforcers, data protection experts. So that is, I think we can consider the recent commission decision that sets the high-level expert group as a sort of a declaration that there is consensus. We have acknowledged this. It's digested. Let's move in that direction. But because I'm a lawyer by background, I was reading this decision, and because I'm part of the civil society, I was again thinking, what is going to change for me specifically? How are they going to change my life? And I've noticed two things that might be a challenge in the possible functioning of this high-level group and in the role that it can play in the enforcement of the DMA. Because if it does play a good role, if it does play the role that is supposed to perform, then by all means, it's going to enrich the enforcement. It's going to make the enforcement much more capable to address the different nuances and to include in the assessment all the data protection and privacy elements that do matter. There are these two things that make me think, wait a sec, maybe it's not the best we could do. The first one is that it seems from the decision that the high-level expert group is going to provide advice and expertise, which is good, but only at the request of the Commission. So it means, it seems to me, and I would be very glad if someone proves me wrong and explain me why I got this wrong, that the European Commission say, we set this beautiful group of excellent experts, and we let them sit there. And if and when I want to have an advice, nothing more than an advice, I'll knock their door and say, hey, I'm doing this. Can you provide an advice on X? I really don't see the point of why this should happen only at the request of the Commission. The second point is that explicitly, this decision says that the high-level expert group is not going to be able to intervene in any investigation or in any open proceeding, which means to me, once again, prove me wrong, please, that if the European Commission is investigating about the compliance with a specific provision, this is an open proceeding. And so the high-level expert group cannot have a word on that. It cannot say anything. It cannot intervene. It cannot provide any sort of a recommendation. And so then I think, so why do we need it for? Do we need it for, advices on, in theory, how the cooperation and the dialogue between the competition enforcers and the data protection enforcers should work? Fine, fair enough, but we can have it separately from the DMA. This is a topic that is of interest for many other regulators as well. And this is something that they're doing in the UK, for example, irrespective of any specific framework. But how is this high-level expert group that is established under the DMA actually going to impact on the enforcement of the DMA if they cannot intervene in any open proceeding or in any investigation, if they cannot have a say on whether a gatekeeper is actually complying with Article 5.2 or not? So that seems to me a little bit sort of the wrong starting point.
So if there's a Commission problem, that means they probably won't be incentivized to seek an opinion from this high-level expert group anyway. And there's no point in having such a group if it can't proactively, of its own volition, intervene.
This is something that they can do that already now.
Yeah.
So my question is why we needed to set up a high-level expert group. There is nothing now that impedes a case handler at the European Commission to say, look, we do need or we would benefit from an opinion from the European Data Protection Board or from a data protection authority. We could seek this formally or informally. I don't think we need such a big step as establishing a high-level expert group to help in the enforcement of the DMA if this is just, every now and then when we just need it and it's an advice, but by all means not on a specific case that we're actually dealing with.
Go ahead.
Just want to ask rhetorically, how many provisions in the DMA are box ticking, actually?
That allows me to go back to my first point, which is it's absolutely essential that we don't look at the different provisions as a ticking box exercise. It's none of these rules taken in isolation is going to provide as meaning this time end users, but also business users, with contestability and fairness. It's impossible. None of these rules is a game changer by itself. So the minor tweaks and forgetting about the fact that all these behaviors, they're all tied up into a specific business model, this is not going to work. We need to always go as deep as possible, and ask all the excellent questions that have been raised already about the specific enforcement of each rule for a number of good reasons. Proportionality of intervention, legitimacy of intervention, and so on and so forth. But all this needs to be done, always keeping an eye on the fact that what we're dealing here is contestability and fairness in the market. And this can only be addressed if we impact, in a way, on the gatekeeper's business model. Because the gatekeeper business model has reduced contestability and fairness. And this is not my interpretation. If you read, everybody has read all the obligation in the DMA, but I do invite you to read just the recitals. Forget about the rules. Read the recitals. There are plenty of super interesting things in there. And they say this. They say exactly this. They say that contestability and fairness are interlinked. They say that it's about avoiding that gatekeepers are able to establish as industry standards deep, invasive business models when it comes to collecting data. It's all in there. It's a very good reading. I do recommend it.
Now, we are not market participants, we three, but you are. And maybe you can give us a sense of what it's like with this hopefully game-changing, much hyped new regulation. You have been making submissions as a third party. Take us into that process and whether that has had any consequence so far.
And we have actually started to do so 2 months after the DMA was agreed upon. And so we started by publishing a number of principles on fair and effective choice and switching mechanisms together with other search engines. And, I would say that the Commission has proven to be very open for engagement with companies like us. They've been valuing a lot the fact, I believe, that we've maintained a common approach. And so we've really tried with our friends at Ecosia, Quant, Mozilla and others, to at least coordinate and then, when possible, to come together to these meetings with the Commission and to build a common approach, which I think we've succeeded in doing. I would say really the one thing that is missing right now, at least when it comes to these obligations that we are looking at, is really the start of this genuine constructive dialogue with the gatekeepers. And by this, I mean really presenting factual mock-ups, designs. How is this going to work? And I think that we take this really from our experience with the Android antitrust decision, where there was a choice screen mandate. This choice screen mandate was really left in the hands of Google to design, which meant that they came up with the worst possible implementation, not for them, obviously, but for us and the users, in the name of a system that was based on an auction, and that had as an effect to exclude the privacy respective options. And, it took years and publicity and op-eds and so to finally get rid of it. And now we have something that is better than nothing, but really literally had no impact on the market just because it's not very well designed and it's not seen by many people. It's been designed, shortly speaking, by Google to try and preserve the status quo and preserve their interest in the platform.
That's a very mean thing to say about Google, what you said there. And so when you make these submissions, I asked you before the session, is it like you've dropped a pebble down the well? Do you hear a splash? I mean, does the commission notice, tell us about the response. Is there one?
Yeah, and I want to acknowledge the fact that we have good conversations with the commission. We always try, right, to walk this on the edge of because they are saying in the workshops, for instance, that they don't want to look back at previous cases, but on the other hand, we are trying to build our argument on the basis of what we know, right, which is the underage touchscreen.
He who forgets history is doomed to repeat it. I think a wise person once said that. Anyway. Exactly.
I would say that the missing bit now is not these conversations, but really trying to you really start this dialogue where either with one or several gatekeepers, we really open in the modalities of discussion that there is actually really a product-based exchange, where it's like this is how we are thinking of implementing it, and then we are able to provide comments. And when I say we, is like we as a group of search engines, but also consumer organizations and civil society organizations should be able to do that. So that eventually by March 2024, which by the way is around the corner, we are able to have something that works from the get-go, and that is not a repeat of what we've seen with Android or, God forbid, with the cookie banners where
But that can only happen if the Commission is driving this process, or at least willingly allowing itself to be brought along, because the gatekeepers won't be pushing that. So are you seeing any momentum, any urgency?
I think the Commission is, and they said it, very busy right now with the designation procedure and the delineation of gatekeeper services, which is a bit more straightforward when it comes to search and browsing, although not everywhere. But we would like to see by September something, and I think that the Commission said very recently that they're going to open for consultation a draft compliance report. So what the gatekeepers are supposed to provide as of March 2024. And this is very important. We are very much looking forward to this draft because this is possibly the most important reporting tool that is in the DMA for not only the Commission but the general public. And that the Commission tells what the gatekeeper is supposed to put in there and tells it in great details, including why they went for a given option and not the other one, is really essential. And I think another thing that should be put in these reports is also some metrics, some KPIs. So example, if you ask the gatekeepers to report how many of the non-themselves options have been chosen on a choice screen, and you compare between platforms, you can pretty easily see, which platform is doing this well and which platform is doing this in a way that protects its own service.
Okay. Before I ask Klaus a question, if anyone has questions, start pulling your ear and I'll try and spot you. So Klaus, there was this efficiency test and we still have a whole lot of economics. And whatever it is, maybe it's mumbo jumbo, maybe there's a bit of science to it. It was some sort of a system that the competition community understood. But now we're entering this new system that you're describing. And one thing we've learned over the last 5 years is that there's even more opportunity for chicanery or neglect when you don't even have, whatever sort of structure economics provides. So, reading the text, how thought through do you think enforcement is? I mean, what do you see coming? That's a big question.
Well, that's very difficult to answer. I mean, the good thing that you take it away from these purely efficiency-based ideas is that you may make the proceedings quicker. Look at how long the Google Shopping case took to decide. That was 10 years or 12 years because you had all the back and forth. So you have this hope that when you clearly define these cases in Article 5 and 6, that it's easier and quicker to enforce. I think the problem is that you may not cover cases that are not in there because it's a closed system. It's case-based, so to speak. It's limited. I mean, I know it can be extended in the future, but we all know these processes take very long. So I think if I were a gatekeeper, I would try to build my business model in a way that just is as effective as before, but doesn't infringe Article 5 or 6. So, and when this is what the problem that we have, and which compared to competition law, which is way more open, and then of course you can build new groups, etc. So I think this is the problem, that you have this huge inspiration from the past, where we have had cases like the Facebook case, or Google Shopping, Amazon, etc., who were of course very problematic, but now we just made them a law, and the question is what other situations will come up, and will the Commission and the EU be quick enough in addressing them?
Okay, and it's useful. I mean, we're implicitly all being a little bit critical.
Yeah.
Even trying hard not to be in your case of the Commission. But, you know, if you think about the news yesterday from the court, from the European Court of Justice, where DG Comp had requested, it now turns out, completely legitimate materials from Meta, and then had to fight a long court case to be allowed to actually ask that question. They were being obstructed in what turns out to be quite routine procedure for a long, long time. Okay, so I see two. There's one gentleman standing at the microphone, which means he wins. Well done, sir. So when you ask a question, could you let us know, you know, if you work for a gatekeeper or not? And beyond that, tell us who you are.
I'm Alexis Art from Leiden University. I'm doing my PhD and very much working against the gatekeepers. My question is to all of you, but I was not sure, listening to Claire and reading the recitals myself, I'm just, the way I see it, the DMA adopts this normative framework of contestability and fairness to a business model, or in the business model, that in a way is illegitimate. And it's very confusing, like reading everything holistically, you know, DSA, DMA, consumer protection law. The business model that most people here would agree is illegitimate. Then the DMA comes up and says that we have to have contestability and fairness within that business model. And I'm a bit shocked, like, how does this go together in the entire, you know, the commission process of creating this competitive market in the digital sphere, and it's based on the fact that the business model. But it was supposed to, like, DSA is going to, you know, make sure that the harms are protected against. The consumer protection law is going to do that, or the GDPR is going to do it, but it's not doing it. I mean, they literally limited the prohibition of the tracking and the ads in general from the DSA. They raised it. So now we're left with basically the business model being allowed, and then within that business model, you have a really contestable market. So what are we going at? So this is my view, and I want to hear, like, if you also read those recitals my way, or you think that it guarantees that, that true contestability that we actually want. Thank you.
That is a nice question. Thank you.
Yeah, it is.
So there are a couple of things in there. I do agree, but allow me to do this. So you say the DMA looks at contestability within the business model. I would say that the DMA is mostly oriented to create competition within the ecosystems. So it's sort of a intra-platform competition rather than inter-platform competition. And I think there are very few provisions that have the potential to create inter-platform competition. I agree. On this, we're on the same side. It's the way I read it. So I'm using these different words, but I think we're saying the same thing. I agree with most of your concerns, and I agree on the fact that also the DSA, although it's a very, very good piece of legislation potentially, because it sets some specific limits and it does that to protect other values than economic efficiency. And it's also a good approach because it's like an incremental approach. So the bigger you are, the more your behavior can impact certain values and rights. So the more you need to take care of what you do, basically, with all these limits, etc. But I do understand it. It could be read like, okay, we're just trying to fix what's existing. We're not trying to change what's existing. That's my major fear as well. The only thing I can concretely suggest you, and the only call that I have for the enforcers, if we're talking about this, is that the key could be freedom of choice. If we do guarantee freedom of choice, which, by the way, choice is mentioned 28 times in the DMA, and fairness, which is one of the main goals, is only mentioned 18 times. So it is about choice. It's not just that I'm a random civil society person saying, I want choice. It is about choice. And choice is one of the elements that at the individual level is gonna be helpful to sort of rebalance the negotiating power between the end users and the gatekeepers, between the business users and the gatekeepers, but at a collective level is also trying to sort of rebalance the situation between demand and supply, because what we face today is that it's not demand that drives supply. We as consumer base, as users base, we have to deal with what is offered, and we have very, very little possibility to sort of nudge what we want to see in the market, to call for something different, because we have no option, we have no choice. So once again, the main point is let's try to interpret all these provisions when possible in a way that allows us to have choice. There are some provisions in the DMA, I think, that they're more directly towards this potential. Interoperability provisions is an easy choice, is an easy pick, sorry. But many of them, they could be read in this lens, and I think it could be a good thing to go in that direction as much as possible.
Either of you want to come on that? Yeah, you both do.
Well, just very quickly, I think choice is one thing, but I think a problem is that users are too comfortable. They just use Google because it's the easiest and most convenient way. And I mean, there are other research engines, there are other platforms, but they are kind of stuck in this behavioral bias that it's just what you do and you don't think about it. So I think prompting users and asking them is actually, what is also in the DMA, is actually quite a good way, at least to take a bit of users away from the big ones.
Yeah, just want to add that guaranteeing choice is also a very tenuous, hard process. Looking at the details, the design, the dark patterns, and there was a search engine in the US called Niva, who recently had to shut down, and in their announcement, shutting down a search engine, the first reason the naming is this. Is like the unnecessary friction in switching, which basically is dark patterns, and this is what the DMA is addressing. But like to address it requires this really looking closely at the details. Now I see that the line is.
And this search engine was run by the former head of search
at
in
Google. So he knows the business.
Yeah, but one of your questions really was, we were getting into the detail there a little bit. One of your questions was about the interplay between these two things, and it's maybe a bit of a corruption of one to make the other one efficient. And this is a problem we have in European law. For a long time now, we're not seeing the Commission actually monitor and make sure that law is applied not just in digital, but everywhere. As a guardian of treaties, it's not really so much a wonderful guardian. So I share your fear that we're laying down new sedimentary layers, especially of digital law, and they're silting to the bottom. And if the law below you is not enforced, then you start trying to solve problems you should not be trying to solve.
You're legitimizing things. This is, I think, the biggest problem, is that you might legitimize and you might expand the time until this comes to an end.
And we've seen this with competition cases between also-rans in tracking against big players in track. I mean, it's ridiculous. Okay, maybe another question.
Thank you. Thanks a lot. Tommaso Falchetta from Privacy International. We also campaign for the use of the competition framework to address privacy violations.
Tommaso, could you speak up because
Yes, yes.
the people behind are quite loud.
Oh, sorry. So my question is for all the panelists. To what extent do you see the DMA is opening the space for civil societies to be included as a player in the enforcement? Thank you.
It's your turn.
What's the question? Thanks, Tommaso. What's the question? What I see happening or what I wish?
Well, I guess both. We have been advocating for certain provisions in the DMA to give some opening to civil societies. As you have all said, this hangover thing, then you have to look at implementation, whether those provisions will actually become effective to give civil societies an opportunity to intervene in the context of monitoring and enforcement of the DMA. Is obviously maybe it's too early, but at the same time, I think there are some concerns of the way the Commission has yet to develop some of the guidance on how to kind of open the space for civil society. Thank you.
Okay, I agree. I do agree. There are some entry points, as we know. There is Article 8, a few more articles. So there are a couple of entry points in there where civil society, end users, but in general, I suppose also civil society, they could be included in the enforcement, if nothing else, by providing comments on the way gatekeepers plan to comply with some obligations, possibly also, hopefully, on the draft enforcement reports, and so on and so forth. My main concern in there are two. First one is because I would say, this is my reading, it's not common for civil society to be involved in the enforcement of an economic regulation or a market regulation. Which is not necessarily only an economic regulation. What we need here is a plus, I think, from the European Commission or from the different enforcers in general, which is we need to create an easy way for civil society to be involved. Some of us, we are a little bit more into these conversations. Others, they could contribute, but they don't know how. They literally don't know how. So we need to do a little bit of work to empower civil society to be included. And we can't, I don't think the enforcers, they can just expect the civil society to be ready to do that and jump on board as any other sophisticated market player. So this is one. The second is, are those entry points enough? Is civil society and I suppose also business users or other actors, academia, etc., involved sufficiently, in theory at least? One of the points I want to go back to is, yes, you mentioned the key performance indicators. So how we are going to assess what we are going to use as parameters to say, yes, we like this draft enforcement reports, or we don't. We think they go far enough, or we don't. This is supposed to be done on non-confidential versions, or this is supposed to be done on short summaries of things. How much material we're going to be able to actually see in order to properly comment on it? There is a huge, as we know, there is a huge asymmetry of information. So if we don't solve this issue, all those entry points will be sort of weakened or become completely useless. There is a last point that I want to make, which is, I think this is an essential element in the enforcement picture, and I want to go back to the fact that we need, say, one of the very good success for the DMA, I would say, is to sort of empower again demand to drive the supply, and this, allowing civil society and other stakeholders to become more active in these kind of conversations about, what is a good enforcement, what is compliance, will also contribute to making, again, demand having a say on what supply should do. Yeah.
We've also got a problem on our end. You don't have it in Privacy International. You don't have it in Article 19. but there are many organizations, rights organizations, where using the word market is not seen as appropriate or relevant. So unfortunately, there's plenty of voices that should be in this discussion, and they deprive themselves of that opportunity. And I remember inside ICCL, where I work, it took a little bit of a process to get colleagues, and I can see you nodding your head, comfortable with this notion that we should be talking about markets and getting into that. And ultimately,
we've done an entire podcast series about this. So.
Yeah, right, yeah.
Yeah.
So, ultimately it's about power, just under different terms.
Hi, thank you for the excellent discussion. Karlo Lukic, Goethe University, Frankfurt. I'm a PhD student doing research on online privacy. I have 3 questions. First one is, why do we actually need the DMA? I know we started the whole discussion with after the GDPR stitching new laws. The second one is basically, do you think it's going to be enforced? And the third one is, I guess the goal of the DuckDuckGo would be, the goal with the DMA would be to increase the market share. But what if actually you give the users the choice, and then there is the privacy paradox, basically, that no changes basically happen after, or say no significant change happens after the.
So should we take those in order? Why do we have it? Klaus, do you want to go into that?
I would have answered to the second question about
okay.
the enforcement. What we have to keep in mind is that it's self-executing. So actually, they should apply to it by themselves, which I think is also a bonus that you do. There's no decision necessary to have them follow the rules. At least for Article 5 and for Article 6, you can do these specifications, but the general rules apply per se. So. And then will it be enforced? Well, I guess so, yes. I mean, they are in talks with the gatekeepers already on how to implement it at large. And I mean, in Germany, you have the Bundeskartellamt cases who are very active in going after the big ones at the moment. I mean, of course, we have national competition law in Article 19a, etc. Like this discussion, but and whether or not it's applicable, that's another case. But I think enforcement will take place. I wonder how much change it will eventually bring about. This is actually the core question, in my opinion.
Do either of you have thoughts about why did we need this in the first place?
Yeah, quite. I mean, I mentioned before the Android case. So it's a case that took years, 6, 8, I don't remember, years to conclude. Led 2 years later, to a remedy that was, as I mentioned earlier, not working at all, or even being counterproductive. And then again, an extra 2 years to do something a bit better. So I think the idea is that with this antitrust wisdom that we've acquired in Europe and elsewhere, because some of the provisions, are inspired by things that didn't necessarily happen in the EU. We found, collectively that there was a number of practices that should be banned, regardless of which gatekeeper does it. And so I think that's the idea. But it's true that it's a new systemic regulation that is really a new model, and it's a bit hard, to get it compared with regulation in other sectors, be it financial or telecoms, because these are differently structured. So it is a new framework that is going to require a new type of engaging with the companies in the scope. But I think we can be reasonably optimistic about enforcement, given the number of organizations that actually want that. The fact that also at some point, organizations will be able to go to court to get the DMA enforced. That the Commission has a pressure to act, and that a number of other national authorities are also going to be able to contribute. So I think that we are seeing this with enthusiasm, cautiously, and to answer to your second question about the market share. So the reason that we've been so supportive of these provisions, so that a trust screen mandate and removing the frictions for switching, is really based on like surveys, like hard facts that we had, right? That we published actually online, surveys we did, experiences in other countries, and experiences also with the existing Android trust screen, where it doesn't have an impact on the market because not enough people see it. But if you look at the behavior at those who actually see it, we do see some positive impact there. So meaning that if you expand it and make it better design, it will have an impact on the market.
Now, we're approaching our last 10 minutes, so should we move on to the next questions, or is there anything pressing?
Just one very, very small comment. I think what's going to be very exciting is how private enforcement will take place. This is something like another big question coming up, but I think we should rather look at the queue and see.
Yeah.
Look at the other questions.
Thank you.
Thank you. My name is Viviana Perez. I'm from Leiden University, and my question is regarding privacy, so maybe we can talk now. I would like to ask you, or we can talk a little bit about the obligation of data sharing. Seems for me that this obligation has a privacy concern really big, so maybe we can talk to which extent this obligation is really important or will really help to help the competition problems, considering the data privacy problems that it can bring.
Do you want to go first? I do.
Well,
have,
okay.
Yeah.
I think the major issue here is that the sharing of data, as a rule of thumb, it promotes innovation and competition. So actually the sharing can be beneficial, not only for the actors, but for better services, for society, etc. So that's the one side. And of course, on the other side is that you have to have a legal basis for the transfer. So again, the DMA looks at consent, which in most cases, to be fair, is the only legal basis that is applicable. Because when you look at the moment you share the identity of people, well, legitimate interest is not enough anymore. You cannot expect, people do not reasonably expect that their data are shared with anyone in the world, more or less. So I think when you closely look at the legal bases, and if you are dogmatic about them, then you'd say the consent is the only one, which can be a major block, of course, because people then do have to consent actively. I don't know how to strike that balance, but at the moment, again, like getting back to my presentation, I think consent is the best we have, even though it's far from being the perfect world. I mean, it reminds me of these competition law cases, like in GDF Suez, for instance, where the sharing, this company, electricity company, which was state-run and had like data of all the French citizens, more or less, on their profiles, etc. Then the market was liberalized, and then the question came up: how do competitors get access to these data? Would it be fair not to give them those data? And then what the competition authority was, summarizing a lot here, so it's of course way more complex. They said, well, we do share, but people can object before, so they have a 30-day period to object, which would not be possible at all under the GDPR. It was ruled invalid in another, not this case, but in I think it was Planet 49. It was very clearly said that you cannot have consent by just asking people, hey, we do it, but you can object if you don't want to. That's not consent. It was not consent under the directive. Now it's not even less consent under the GDPR. These are the cases where you really see this balance, where actually the sharing would be very beneficial for users, but data protection can block. But at the same time, if you take data protection seriously, then you have to have this blocking effect, because otherwise it's useless. So I'm sorry, that's not really a straight answer, I know, but it's like this problem is very, it's impossible to solve that, at least for me. If someone can solve it, Isa, for instance.
I don't.
And now, Isa, we've 8 minutes, so brief, please.
Yes. I don't. The only thing I would add to that is that those are very complex issues, because it's about balancing different interests and values for society. And where to put the red line is going to have a huge impact. What I think needs to be done is to avoid that this kind of conversation and this kind of decision are taken behind closed doors by only few of the stakeholders that are involved. This is more sort of a societal issue than a strictly economic issue or a thing that concerns a single company for as big as it is. The impact is on society, so I think it should come. The decision should come from as much as possible from a public debate.
Thank you.
Hello, I'm Farid Masouli. I'm a student in law and technology at Tilburg University. So my question is about data portability because you briefly mentioned it. Basically, data portability is one of those rights that, if it works, is supposed to address, well, freedom of choice, so choice issues. It's supposed to reduce friction for consumers. It's one of those rights that, yeah, if it works, it can really address everything. And yet, I mean, I'm writing my thesis about it from the point of view of the Data Act because it's even more fragmented than other rights maybe, because it's like you have pieces of it everywhere. How do you see it play out with the DMA? Because, of course, I mean, we all want, I mean, for consumers, for privacy, for competition, I don't see it talk that much. I know Max Planck Institute, like in the Data Act report, they talked about it. There are some works about it. There's one big PhD project, I mean, from several years ago. But overall, it's not talked that much. So how do you think it plays out? And why do you think it's the case for
Who wants to take that? Anyone have any strong thoughts? No, he's
data
not.
portability, no, not really.
The only thing I want to say is that I agree that it's not going to be enough. And in fact, it's one of the typical examples where I was calling before and saying, you know, we need to look at the different provisions, not in isolation. So if we focus on data portability and we try to implement it in the best way possible, and we don't look at switching, which is what you have mentioned many, many times. We don't look at the provisions about dark patterns. We don't look at the provisions about bundling and tying. We don't look at the provision about interoperability. We're not going to get there. Because it's, even if from a strictly data portability perspective, I have everything I need, where do I go? Where do I go? I need the rest of the picture as well. So that is a great example. Thank you for providing this example of what I tried to argue before. It's much bigger than the single specific thing in isolation. It's not going to be a game changer. I agree.
Okay,
Otherwise.
let's see if we can get the last two questions very quickly.
Hi, I also have the questions regarding the data portability, especially whether it's interplay with GDPR and the obligations to provide real-time access and technical tools to provide this real-time access. So, for example, the GDPR, they have times to provide for 30 days. The data controller to require the to accept the request within 30 days, but for the gatekeeper, you have to provide real-time access. I just wondering whether this would be like a problem with security measure for this data portability obligations. Thank you.
Does anyone on the panel know anything about this?
I'm quite sure it will be an argument brought about by the gatekeepers that you have a security issue in these cases, but...
But would there be like a guideline on how to provide a more continuous... When we say continuous access, that means the end user can always ask for to request the data. So, yeah, like how do you see this obligation? Is it feasible? Yeah.
I'm not sure about the technicalities. From what I hear from tech people is that this idea that you have this continuous flow of data from one operator to the other doesn't work in practice. But really, that's just something I heard. I'm not a technical person myself. I mean, what the DMA tries is to put the GDPR data portability right on steroids, because there were many major flaws in there, which is why it never worked. It was not successful at all from what I know. And one of the big issues was the real-time access thing. Also now it covers non-personal data as well, which is a pragmatic in that it avoids this whole discussion of what is personal and what is not personal. It also refers to observed data and not only to the one given by the user. It doesn't arguably refer to inferred data, where we have the trade secrets aspects coming in there. I think this is a bit disputed, but I think from the wording of the DMA, inferred data are not covered. So, well, in theory, it should be better, but I still wonder in which cases it would really benefit someone, because the idea is nice that you can just take your data and go to another provider, but would it really work in practice? I'm not sure about this. I think it depends very, very much on the service you're talking about. For some, it may make sense. For others, probably not.
Okay. And last question, Christina.
Hi. It's also a question about the interplay between the GDPR and DMA. So data combination...
We cannot hear you, sorry.
Data combination is a strong element of data power, as prescribed also now in Article 5 of the DMA. Regarding the GDPR enforcement stance, the GDPR was not very successful in taming data combination. So there are some cases, for example...
We're in the last 2 minutes.
CNIL versus Carrefour on cookie syncing, cookie matching, IEB TCF and the Belgium DPA, wherein data matching from online and offline sources is still occurring. What are the lessons from the lack of enforcement regarding data combination of the GDPR can the DMA learn from?
I mean, I'm in that TCF case, and the lesson there is the GDPR did not really get enforced, right? And we're moving for something better.
What will change regarding the DMA on data combination?
We don't know, and we're not going to solve it in the last minute. Does anyone have a final word to say on that question? You're itching.
It's not about that. It's just that finally I heard the word power.
Yeah.
At the end of the session, an hour and a half session, she said data power. Data. You said that.
I said that.
Sorry.
I did say that during my presentation.
So now, having singularly failed to answer the question that summed up the entire panel, let me thank Article 19 for organizing this, and also let me thank Mark Dempsey, who at last minute stepped in to put this together. Thank you very much, everybody. I hope you enjoy your next hangover in 5 years. Well done.